Hey everybody, this is Mr. Mop coming at you with another APGov video. This one taking a look at topic 3.7 and the concept of selective incorporation. Now note, we have touched on this concept a little bit previously, so some of this is going to be review, some of it's going to be new, and it will be including the McDonald versus Chicago case that is going to be a required case for the APGov test. So, with that being said, let's get into what we're talking about here with regards to the idea of, selective incorporation and where it kind of stems from. Remember, when we talked about incorporation previously, from the case of Barron versus Baltimore before the Civil War in 1833, the court had originally ruled that the Bill of Rights only applied as protection from the federal government, not as protection from the state governments. But following the Civil War, we see the 14th Amendment ratified in 1868, which does provide protections for rights and liberties from state governments. So this is going to be important. And there are two parts to the 14th Amendment that are used as the rationale for this idea of incorporating the Bill of Rights to the states. And that's the Citizenship Clause. And in the Citizenship Clause of the 14th Amendment, it states that we are entitled to basic privileges and immunities that cannot be denied by the state governments. And then there's also what's called the Due Process Clause of the 14th Amendment, which is the same thing as the Fifth Amendment version of due process, but it's applied at the state level, which is basically saying that the states cannot take away life, liberty, or property without due process of law. So remember, with the 14th Amendment, we are now seeing the opportunity for the incorporation of basic liberties, not just at the federal level, but at the state level as well. But note, as we've said before, the incorporation of these civil liberties is not done in one fell swoop. It's done on a case-by-case and liberty-by-liberty situation, and that is why it's called selective incorporation. And what we've basically seen, going through the 20th century up until the beginning of the 21st century, an individual case-by-case and liberty-by-liberty incorporation process that's going to be happening. The first of which starting with the case Gitlow v. New York, which is going to be applying freedom of speech at the state level. And then shortly afterwards, Neer versus Minnesota, which will be applying protection at the state level regarding freedom of the press. Now, you don't have to know the Gitlow case or the Neer case by name, but understand, as you could probably imagine, it's not a surprise that these are the first two cases, or first two liberties, rather, in the Bill of Rights that are incorporated at the state level. Basically, the court has always viewed freedom of speech as our most important liberty, basically. And notes that just about basically all of our civil liberties from the Bill of Rights have now been incorporated at the state level. I mean, there's a couple of exceptions, like the Third Amendment and whatnot, but just about all of them have been applied. Now, here's what's interesting. The most recent of these is the incorporation of the Second Amendment at the state level. Now, you may recall that previously we talked about the case D.C. versus Heller. And D.C. versus Heller, if you don't remember, was focusing in on, what the Second Amendment really means. What does it mean when it says that in order to, when it talks about the right to bear arms, keeping in mind that a well-regulated militia is necessary for, to protect freedom, and you have the right to bear arms. What does that actually mean? Well, as we said previously, the court has said that the right to bear arms is not simply a communal right that is only applicable to the military, the police force, National Guard, etc., but it's an individual right that we all get to enjoy. Now note, D.C. versus Heller is talking about a federal legal situation. It's the District of Columbia that had outlawed the possession of handguns. So when the court makes this ruling, it's talking about here's how you interpret the right to bear arms at the federal level. Okay? But note, that's just at the federal level. There were many state governments across the country, local governments, municipal governments, that had, bans on owning, possessing certain types of firearms. And one of those was the city of Chicago, Illinois. And, not a big surprise, once the DC versus Heller ruling comes down, we see a lawsuit against the city of Chicago in this case. And what Otis McDonald is basically arguing is that, hey, he's a guy that has been the victim of crime in the past. He lives in a bad section of the city of Chicago. He feels that he needs to own a handgun for legitimate, protection of his life and property, things like that. And so the argument being is that, if we've already defined what the Second Amendment means, does this liberty apply at the state level as well? And in this case, it's going to be a 5-4 ruling. But in McDonald v. Chicago, the conservative majority is going to win out, and will say that yes, that the ability to own a handgun is a basic fundamental liberty that is worthy of incorporation, just like freedom of speech or the right to have an attorney or anything along those lines, that is also to be incorporated at the state level. So states cannot just arbitrarily take away somebody's ability to have a firearm. And so, that's kind of where we've gone with this. So McDonald is the one that you have to know for the AP test, because it really is stressing the idea of incorporation. That's the big thing you want to kind of take from it. Once again, it's not the first case that's incorporating a civil liberty, but that's the one that they've chosen to be the significant one in terms of the idea of incorporation. So you want to be able to differentiate between McDonald and the DC versus Heller case. Now, since the DC Heller case and the McDonald v. Chicago case, there's a question of, okay, if gun possession is a fundamental liberty that is an individual right that the federal government cannot take away, that the states cannot take away, well, how far does that liberty go? It exists, but what are the boundaries of it? And the court really hasn't given any, clear, absolute idea as to what that means yet. Because the court has not chosen to take on cases yet that deal with state bans on assault weapons. They have not taken on state bans regarding concealed carry opportunities and things like that. So, we know that almost certainly that the right to own a firearm is not an absolute right, just like the right to speech is not absolute, or, the right to, freedom of practice one's religion is not an absolute liberty. We just don't have a very good sense of what those boundaries are at the moment. And when you don't have direction from the court, and you have a Congress that is pretty much gridlocked on most things, especially on this issue, the best guidance that we can kind of get is going to be, at least at the federal level, in terms of executive orders that could be applied to it. And note, that's very limited. But we saw in the case of President Obama, he's going to issue an executive order that is going to be applying to the ability of the federal government to provide Social Security payments. Now, that's through the Social Security Act, but rules on how that is enforced. Obama issued an executive order applying the enforcement to the idea being that if you are considered mentally disabled, you are not allowed to own a firearm if you are receiving Social Security benefits, if you are mentally disabled. Now, President Trump's going to overturn that. So once again, this shows that executive orders only last, or can last, only as long as a singular president is in the White House. But it does give some sense of maybe where we can go with some of the clarification of how far gun liberty rights go to. But note, I would expect, sometime in the not too distant future, we will see the court start to take up some cases that are going to be, giving us a little clearer idea as to how far gun rights go in terms of incorporation. So, all right. So we will leave it there for now. We'll see you next time.